The Special Marriage Act, 1954. The Special Marriage Act, 1954, is an act of the Union Legislature that provides for special forms of marriage governing all Indians, within or outside the territories, irrespective of their religion and customs. It generally governs inter-caste and inter-religious marriages. Introduction. India is a country with diverse cultures and religions. However, inter-caste, inter-religious and love marriages are not very common in Indian society and usually not accepted. Honor killing is also a reality in India, which discourages people to marry of their own choice. Thus, it is necessary to protect the interests and lives of people who choose to marry out of their caste or faith. Background. During the British era, many Europeans working in India began settling down and marrying local people. Thus, Henry Sumner Mene introduced Act 3 of 1870 to grant permission to dissenters to marry of their choice. The act also applied to inter-religious and inter-caste marriages and people who renounced their faith in all religions. This act was later found to be inadequate to bring about the desired reforms. Therefore, after independence, it was replaced by the Special Marriage Act, 1954. The act was given assent on the 9th of October 1954 and came into force on the 1st of January 1955. Objectives. The main objectives of the act are to provide a special form of marriage, its registration and divorce. To provide a mechanism to protect the rights of people who want to engage in inter-caste and inter-religious marriages. Important provisions. Conditions for solemnization of marriage. The conditions which are to be fulfilled for solemnization of marriage are: the procedure of solemnization of marriage. Notice. The parties can give notice in writing, in a format contained in Schedule 2, about their intention to marry to the district marriage officer. The condition is that one of the parties should have been living in that district for at least 30 days before the notice. Notice book and publication. The marriage officer shall keep the notice in the notice book, which should be open for inspection. Such notice is to be published by affixing a copy of it in a conspicuous place. Objection to marriage. Before the expiry of 30 days of publication of the notice, any person can object to the solemnization of such a marriage on the ground of a prohibited relationship. If no objections are received, then the marriage can be solemnized. Appeal. If the marriage officer denies such a marriage, then either party intending to marry can appeal in the district court within 30 days of the order of refusal. The decision of the district court shall be final and binding on the marriage officer. Parties and witnesses. Before solemnization of marriage, the parties and 3 witnesses shall sign a declaration, countersigned by the marriage officer. Certificate of marriage. On the solemnization of the marriage officer shall keep the certificate of marriage in his/her book, which is signed by the parties and 3 witnesses. Criticism. The procedure to solemnize a marriage under the Special Marriage Act, 1954, is lengthy and exhaustive. As such marriages are not well accepted in society, there is a threat to life and property. In such marriages, there are bound to be bogus objections to make the procedure more complicated and exhausting for the parties. Thus, the punishment should be raised so that only genuine objections are entertained. Importance and impact. Even after 70 years of independence, there are many parts in the country where inter-caste and inter-religious marriages are frowned upon and not accepted. Thus, it becomes important to protect the rights of such people who want to solemnize their marriage. The Special Marriage Act, 1954, has strengthened the basic right, i.e., right to marry the person of one's choice. It entitles people to select their life partners without worrying about their caste and religion.